for Outremont. Thank you very much, Madam Speaker. I'm very pleased once again, on behalf of the New Democratic Party, to state that we will be supporting the Bloc Québécois motion on the securities regulation system. And unlike my usual custom, I'm going to make a great many of my remarks in English this afternoon, because I think that there are many people in Canada who may find it more easy to follow along in English. It is very important that they understand that it is not a question of a little local, federal, provincial squabble. It's not a question of stating that we want to maintain a system against the federal government at all costs. So I'm going to begin in English, and I'm going to follow along in the vein of my Liberal colleague. And I'm just wondering something, and I ask myself this question very often when I listen to my Liberal colleagues. Will they join their actions to words?
For Markham Unionville, who just spoke, called the Conservatives' spending of large sums of public money on this issue imprudent and irresponsible. He's right. You don't spend public money on a crapshoot. Right now, this issue is before the Quebec Court of Appeal. The Quebec government has referred it. The federal government is saying that it is going to be referring to the Supreme Court of Canada. I heard the chairman of the Finance Committee, the Conservatives, speak a little bit earlier from Alberta, the riding of Leduc, I believe, and he said that the Supreme Court will rule in about a year. That's not possible. It is absolutely impossible to formulate the reference to the Supreme Court, give appropriate time for the preparing of facta, and hear the case and render a decision. That's not going to take place in a year. That's totally unrealistic. So the money that is being spent, to quote the Liberals, imprudently and irresponsibly on this uniform securities regulator, risks being totally wasted. So that's on the pure public policy angle of it. Does it make any sense, therefore, to have this draft bill and to be spending that money? The block motion simply calls for the government to withdraw the draft bill. Now, that's good common sense. To the extent that even the Conservatives are admitting by their reference to the Supreme Court that it's an open question whether or not the federal government has jurisdiction in this field, and I'm going to give arguments why I believe it does not, it follows, therefore, that the very least that they should do is to stop spending public money on it until that issue is clarified. But my question for my Liberal friends is this, Madam Speaker. I've just said that the New Democratic Party of Canada will be backing this motion because we believe the essence of the motion is to withdraw the draft bill before this House. We agree with that. But my question for the Liberals is, if indeed they feel that the government is spending taxpayers' money imprudently and irresponsibly, are they going to vote with this motion for the withdrawal of the draft bill? That's the only question the Liberals have to answer today. Unfortunately, I didn't get the slightest indication from the Liberals as to what they're actually going to do at the end of the day on this important motion. In any field of modern life, in a democracy such as ours that's a federation, there will be those who argue that the initial federative pact, in our case one that dates from 1867, contains lacunae. It can't contemplate all of the realities of today. I'll use that as my starting point, Madam Speaker, to say that one of the big mistakes we make in our society is to assume that it's just normal to have a democracy that's been functioning, and to use the bromide from our own Constitution, Americans have life, liberty, and the pursuit of happiness. We talked about peace, order, and good government. A lot of people make the mistake of believing that 150 years of peace, order, and good government just comes naturally. It's a given. It's something that can be expected. In fact, if we look at the world and the hundreds of countries in the world, we realize that 150 years of peace, order, and good government is not something that can be taken for granted, because it is quite rare on the world stage not to have gone through a revolution or a civil war or or an external invasion or attack of some kind. That's the good fortune of Canada. But it's not only good fortune. It's because the structure we put in place in 1867, as we created our country, took into account certain realities of the partners who were coming together. One of the realities was that we had the province of Quebec, that was the only province in the newly formed country that had French, of course, as its majority language, but it also had the French civil law as the basis of its legal system. We often talk about a country that's both bilingual and bicultural, sometimes forgetting that we are also bijuridical. In the founding pact of the Federation, it was therefore spelled out that certain things that crossed boundaries, at the time we would talk about railways or telegraphs, that's expanded, and the understanding of that federative pact led the Supreme Court, for example, to say that telecommunications, which is something that had to cover the whole country, was going to fall under those general headings. That's how the Constitution evolved, and that's just good common sense as well. But since the beginning, property and civil rights, understood not in its 1960s connotation from the U.S. and then the battle for civil rights, but understood in its 1860s connotation of the civil law that covers the relations between people, the contracts, the property rights, that was left to the provinces. Now, there are those who would say that we have to follow the American model here. But it should be borne in mind that in the United States, U.S. states individually guard just as jealously their jurisdiction as do Canadian provinces, for very similar reasons. The United States, the most successful democracy in the history of the world, has indeed shown that the institutions that you lay down, in their case it's going to be over 225 years that they've functioned effectively, they laid down their institutional rules. Interestingly, Madam Speaker, in the United States, the state policing power, which is a key power, determines all aspects of licensure, enforcement, and regulation for the professions, as does our federative pact with regard to education. So, for example, even though the dental or architectural or medical professions have their licensing exams in each provinces and could work together in their own associations across Canada, it's the individual provinces that deliver licenses, just as licensure is a subset of the state policing power in the United States. Furthermore, in the U.S., criminal law is determined on a state-by-state basis. In Canada, we've always had a uniform criminal code for the whole country. Very fundamental difference between the two of us. Application of the criminal law can be either at the federal level, or it can be provincially or municipally. The reflex that we're dealing with on the conservative side is a reflex born of a certain conceit that somehow, despite the federative pact, despite 150 years of peace, order, and good government based on the original deal, that somehow when problems arise, Ottawa just knows best. Let's look at the facts. The OECD ranks regularly the relative performance of its member countries in important policy areas. In recent years, it has rated competition laws and policies, the regulation of the banking industry, and the quality of securities regulation and investor protection. Now, let's look at banking regulation and the 4 countries that are covered: USA, UK, Australia, and Canada. Banking is and always has been a federal jurisdiction. Canada is ranked 8th for its banking regulations. It's ranked, for example, behind Australia, but it's ranked ahead of the UK and the US. On securities regulation, the OECD says that Canada's extant rules are the 2nd best in the world. We're ranked ahead of the US, we're ranked ahead of the UK, and we're ranked well ahead of Australia. That's not the opinion of the Bloc Québécois. That's not the opinion of the New Democratic Party. That is the Organization for Economic Cooperation and Development, an extraordinary group that's produced these objective studies. So how is it that we've gotten to the stage where the federal government keeps forcing to take away jurisdiction that has been with the provinces for 150 years? What's the rationale behind it, other than the prejudice I just spoke about, this feeling that somehow Ottawa knows best? Well, again, let's look at the facts. Recently, there was a case of an alleged $100 million mortgage fraud in Alberta. First thing we heard from the police, the RCMP, was they didn't have the resources to take on the case. That's an interesting admission. There's something called the Integrated Market Enforcement Team, IMET. It has been a complete failure. That's not our opinion. That's the result of objective outside analysis. One of the issues that gets raised constantly, and I often hear the parliamentary secretary to the Minister of Finance use it as one of his touchstones, is the Earl Jones case. Now, for people from outside Quebec who might not know the name immediately, Earl Jones was a criminal. He's in jail now under the Criminal Code. He was not registered anywhere. He was not certified anywhere. He was not licensed anywhere. He was a criminal, pure and simple, a fraud artist, a con man in the proper sense. He took people's money based on the confidence that he established with them. In other words, Earl Jones, a criminal, would have gotten around any regulatory scheme, be it federal or provincial, because he never registered anywhere. That hasn't stopped the Conservatives from trying to use that sad case as an illustration of the need for the federal government to invade an area of provincial jurisdiction. Well, I'm an attorney, Madam Speaker, and I've been dealing with corporate and commercial law for most of my career. So I'm going to read to you from an official court document. From the Superior Court of Quebec, the case involves Virginia Nellis, one of the many people who were defrauded by Earl Jones, and the Royal Bank of Canada. Now, remember what I said before. As we all know, the regulation of Canadian banks is the exclusive purview of the federal government. On November 7th, 2001, in an official exhibit filed in court in this case, we learned that the Royal Bank specifically identified the irregular operation of the Earl Jones in-trust account in a note, internal note written by somebody from the Royal Bank, summarizing the account. And it reads as follows. Mr. Jones returned my call. I offered him our RateLink Essential Package service because his fees are over $150 every month. Listen to this, Madam Speaker. He, Mr. Jones, the same fraud artist, is using this account for business purposes as an in-trust account. However, I told him this is not a formal trust account and he could get himself in trouble because this is just a personal account in his name alone. The in-trust does not mean anything in this case. Do you know what the regulatory authorities responsible for regulating Canadian banks did in the case of Earl Jones? They did nothing. Do you know what the Royal Bank did with regard to Earl Jones after that official note in their own file in November 2001? They did nothing. Do you know what the people who were defrauded to the tune of $50 million by Earl Jones got as a result of that? Nothing. In the most literal sense, Madam Speaker, the federal government should mind its own business, should start taking care of its areas of responsibility, something that it does not do. That is the fact of the matter. I used to be the president of a large regulatory agency in Quebec. I was president for 6 years of the Office des Professions du Québec. And I met firsthand this reflex in Ottawa that somehow, if only we could get enough federal bureaucrats to look at any issue in the country, somehow things would be better. I remember coming to the office one day in Quebec City when I was president of the Office des Professions, which is the large regulatory agency that's responsible for all of the regulated professions in the province, to find out that the gnomes in Tunney's pasture, which is where the health department hides out, they had decided that they were going to take over the regulation of pharmacies in the province of Quebec. Much to our surprise, because as in every other province, pharmacies had always been the object of regulation by the provinces. Subset of education, the regulatory structure we referred to earlier for individual professions comes under the provinces. So I called them in, I met with them, trying to understand what they were up to. And they said, well, the rules for what requires a prescription vary from province to province. What can be behind the counter, what can be on the open shelf, what can be behind the counter with a signature, different categories, varies. And we find this a bit of a problem, so we decided we're going to take over this particular area of jurisdiction. Now that's interesting, because of course health is also a provincial jurisdiction. I remember dealing with a wonderful man named David Skinner, who was with a group that was then called the Non-Prescription Drug Manufacturers Association of Canada, sitting him down in Quebec City and saying, this isn't on. You know, the French word for jurisdiction is compétence. And it has the double meaning of jurisdiction and ability to do something. And I flew out to Toronto and I went to one of the meetings of this group after I had met with Mr. Skinner, and I said, you're not going to be allowed to invade an area of exclusive provincial jurisdiction just because some civil servants in Tunney's pasture have woken up this morning deciding that they're going to do that. Of course, we didn't allow them to do it. We were able to block them. And it was absurd to see taxpayers' money being spent. They had organized a big colloquium on this in Toronto. Lots of taxpayers' dollars were spent on this futile effort. Didn't stop the provinces from talking to each other. I remember there was a network that was established of the provinces in matters of professional regulation. We were working together to find the result because it was our exclusive area of jurisdiction. So how did Canada wind up being evaluated by the OECD as having the second best regulatory structure in the world for securities regulation? We put together a regime that allows the provinces to create a passport system that has been producing results. People in the rest of Canada might not know the name Norbourg. Norbourg was the name of a company by another fraud artist named Vincent Lacroix. Lacroix was behind bars serving an 8-year sentence after prosecution by the Autorité des marchés financiers of Quebec, the financial markets regulatory authority in the province, before the first federal criminal prosecution even began. We have no lessons in the provinces to receive from the federal government with regard to the regulation of financial markets. It's worked. The provinces have done their jobs. The federal government has not done its job, and it's astounding to see the federal government simply affirm that it's something that would be better for the country, that we should just allow the federal government to move into an area of exclusive provincial jurisdiction. It's wrong. We know it's wrong, and interestingly enough, some newspapers have tried to say that Mark Carney, the head of the governor of the Bank of Canada, is somehow in favor of the federal government moving into this sphere. It's interesting. I like to read what Mark Carney says, and I have the pleasure to meet him quite often. I've never heard Mark Carney come out foursquare in favor of what the federal government is trying to do. I hear him talk about the importance of having a regime that produces results. That's what we have. Some journalists interpret Mr. Carney's remarks as being an affirmation of him being in favor of the federal government imposing itself in this area. I've never seen Mr. Carney say any such thing. And I defy them to prove to me, in Mr. Carney's own words, where he's ever given his support to that scheme. He's always talked about the need for a regime that works. That's what we have. The passport system works, Madam Speaker. There's never been a problem, and as the old saying goes, if it ain't broke, don't fix it, but that's not going to stop this federal government from continuing to try to destabilize the Confederation, to break the federative pact, and to go after the provinces. Now, if it were only the province of Quebec that was screaming bloody murder in this case, you can imagine how easy it would be for the Conservatives and the rest of Canada. Well, there are two other major provinces that are on side with Quebec, and we're getting an interesting vibration from British Columbia that seems to be about to say the same thing. The two other provinces that are saying the same thing are Manitoba and the Prime Minister's own home province of Alberta. And we'll see what happens.
Questions and comments? L'honorable député de Hochelaga.
The honourable member for Hochelaga. Madam Speaker, we've been talking about this and that, and I'm sure that the member for Outremont was not referring to Quebec cinema, because then he would be talking a skunk. But here's where we see the two solitudes. I'd like him to say in French the entire argument he gave, why we talk about compétence rather than jurisdiction. Compétence because people innocently say something, claim something that is false, that has become a false representation when they say, if we had been there, Earl Jones victims, well, there wouldn't have been any victims. If we'd been there, all this wouldn't have happened. But the member for Outremont showed very well that this is false, and I would like to give him the opportunity to repeat it in my language. The honourable member for Outremont. Madam Speaker, yes, my speech was in English today for the simple-minded across the way, but I will now say it in French, in the language of Molière, after having spoken in the language of Shakespeare. Studies show that the Royal Bank of Canada, which falls under the federal government's jurisdiction, knew before November 2001 what Earl Jones was doing, and they did nothing. People responsible for regulating banks in Canada know that these documents were tabled in court, and yet they've done nothing heretofore, and Earl Jones victims have received nothing, and that is in their jurisdiction. Nobody challenges that the banks are a federal jurisdiction, but let them mind their own business in both the figurative and the literal sense, literal meaning. The banks are, that's their business. They don't do it too well, but they have the supreme arrogance to say that now they are going to invade a provincial jurisdiction, which for 150,000 years has been part of our federative pact. Conservatives are speaking out of both sides of their mouth. They recognize the Quebec nation, and yet they seem to want to go forward with invading a provincial jurisdiction. They say that they recognize Quebec, but every time they act regarding Quebec, it's against Quebec. And they're here saying they're here in the public interest, they're working in public interest, but they should look at the OECD's idea and see that we're the second best in the world.
Okay.
Well, thank you, Madam Speaker. I'm not sure if I qualify for the former speaker's comment about me being one of the simple-minded across the way, but let me try a question. Many times during his speech, he said it was wrong for the federal government to move into this sphere. I'm wondering if the honourable member would also say that these particular groups are also wrong then for showing the strong support for this initiative. The Canadian Labour Congress, the National Union of Public and General Employees in CUPE, Toronto Star, the Canadian Centre for Policy Alternatives report, who noted, quote, the lack of a national securities regulator is a clear black hole in Canada's financial regulatory system, end of quote. Or perhaps his former NDP finance critic, the member from Winnipeg North, Judy Washalisha Lease, who called this a worthwhile goal. Or maybe his leader, who indicated at a Board of Trade meeting just this past January, "I'd like to see us moving towards a national securities regulation." Which of these are wrong? Are they included with the simple-minded on this side, Madam Speaker?
Before I turn it over to the member from Outremont, I would just like to remind all members to be mindful of the language that is used in the House and to use respectful language to all members, regardless of their opinions. L'honorable député.
The honourable member for Outremont.
I thank you very much for calling him to order on his choice of language, because I said the same term as him, that they were innocent, which means that they're not guilty. But somehow he decided that meant he was simple-minded. If that's what he thinks about himself, there's not much I can do about it. But I'll defend him from calling himself simple-minded, and you will too. I think that's a very good thing in this House. You're completely right, Madam Speaker. Madam Speaker, it's quite clear. When you read the case that they always cite as the example for why somehow Big Brother from Ottawa knows best, can come in and take over the field of securities regulation, Earl Jones. November 7th, 2001, the Royal Bank knew that Earl Jones was defrauding his clients. It's here in black and white in the official court documents. Federal government's responsible for banks. They did nothing. The federal regulator responsible for banks did nothing. The Royal Bank of Canada did nothing. Before they try to take over somebody else's jurisdiction, why don't they start taking care of what they're responsible for, but that they're misadministering and that they're incompetent in? They're not capable of taking care of their own things, yet somehow they imagine themselves as being better. The OECD, it's not an argument about the Toronto Star. What a surprise. The Toronto Star wants Toronto to become responsible. What a surprise. Look at the objective elements here. The objective element is the OECD says that Canada's current regulatory structure in the field of securities, the passport system, is the second most efficient in the world. That's why the Liberals say that it's imprudent and irresponsible to be spending money and we should withdraw this bill. That's why the Bloc is proposing to withdraw the bill, and that's why we agree that the bill should be withdrawn.
Questions and comments. The honourable member for Alfred Pellon. Thank you, Madam Speaker. I want to congratulate my colleague for Outremont for that wonderful presentation and the clarification that adds to our motion today. The Parliamentary Secretary to the Minister of Finance said this morning, or he mentioned this morning, all the good reasons to have a single regulator. It was for the good of the entire country, given the fact that there are a number of jobs in the financial sectors and 300,000 in the financial services sector in total that will be targeted by the government bills. Would he agree? To summarize, the government's idea is that they want our assets and they want to have them. The honourable member for Outremont. Yes, that is an excellent way to summarize that idea. A little more seriously, I would say, in reminder to my colleague, that one of the reasons why Canada is such a great success is because we've always understood that the parts that have come together to make up this country had their place within that country. Quebec has managed to create its financial institutions as well as other institutions because of the space that had been given to the provinces, in particular the fact that the only francophone majority province with its civil law had the capacity to build and to ensure that its institutions were respected.
To end in response to my colleague, to say this to the Conservatives. Not only are they making a mistake historically, legally, institutionally, and constitutionally, they're making a mistake politically. Because what they're doing is they're providing more arguments to people who say that the only way for Quebec to be able to survive and keep its talent and its great people is to separate. What they are proposing to do will destroy a large section of economic activity in Montreal, will withdraw from Montreal, some of its most capable diplomates from HEC, Haute Études Commerciales, MBAs and the like, who will no longer be able to stay and work in Quebec in these fields. They'll have to expatriate to where the people are saying that it's a great idea to send it. That's what they're not thinking about. But that's typical of the Conservatives. They never think any further than the end of their nose. They're such ideologues. They believe that simply by affirming that the federal government can do it better, that somehow it's true. Objectively, as we've demonstrated today, it's false.
Resuming debate, reprise du débat.
Resuming debate, the